5 seconds to go. Start. The very fact that more than one charge sheet had been filed against the respondents alleging offences punishable with more than 3 years imprisonment is not enough. As rightly pointed out by the High Court, commission of offences prior to the enactment of MACOCA does not by itself constitute an offence under MACOCA. Registration of cases, filing of charge sheets, and taking of cognizance by the competent court in relation to the offence alleged to have been committed by the respondents in the past is but one of the requirements for invocation of Section 3 of MACOCA. Continuation of unlawful activities is the second and equally important requirement that ought to be satisfied. It is only if an organized crime is committed by the accused after the promulgation of MACOCA that he may, seen in the light of the previous charge sheets and the cognizance taken by the competent court, be said to have committed an offence under Section 3 of the Act. In the case at hand, the offences which the respondents are alleged to have committed after the promulgation of MACOCA were not proved against them. The acquittal of the respondents in crime numbers 37 and 38 of 2001 signified that they were not involved in the commission of the offences with which they were charged. Not only that, the respondents were acquitted of the charge under the Arms Act even in crime cases numbers 1 and 2 of 2002. No appeal against that acquittal had been filed by the state. This implied that the prosecution had failed to prove the second ingredient required for completion of an offence under MACOCA. The High Court was therefore right in holding that Section 3 of MACOCA could not be invoked only on the basis of the previous charge sheets, for Section 3 would come into play only if the respondents were proved to have committed an offence for gain or any pecuniary benefit or undue economic or other advantage after the promulgation of MACOCA. Such being the case, the High Court was, in our opinion, justified in allowing the appeal and setting aside the order passed by the trial court. Thus, in Shiva alias Shivaji Supra, this court took the view that there are two essential ingredients to constitute an offence under MACOCA. First, the registration of cases, filing of charge sheets, and taking of cognizance by the competent court in relation to the offences alleged to have been committed by the accused in the past, and secondly, continuation of unlawful activities. In other words, it is only if an organized crime is committed by the accused after the promulgation of the MACOCA that he may, on the basis of the previous charge sheets and the cognizance taken by the competent court, be said to have committed an offence under Section 3 of the MACOCA. Indisputably, in Shiva alias Shivaji Supra, the accused persons stood acquitted in connection with two of the crimes, and considering the same, this court took the view that the accused persons could not be said to have committed the alleged crime after the promulgation of MACOCA, as the allegations could not be proved against them. However, this court in no uncertain terms has observed that what is important is the commission of an offence by the accused that would constitute continuing unlawful activity, and the unlawful activities could be said to have continued only if the accused are found to have indulged in an organized crime after the promulgation of the MACOCA. The learned counsel appearing for the respondent accused is right in his submission that, having regard to the stringent provisions of the 2015 Act, its provisions should be very strictly interpreted, and the authorities concerned would be obliged in law to strictly observe the said provisions. There need not be any debate on the fact that the provisions of the 2015 Act have been enacted to deal with organized criminal activity in relation to offence which are likely to create terror and endanger and unsettle the economy of the country, for which stringent measures have been adopted. The provisions of the 2015 Act seek to deprive a citizen of his right to freedom at the very initial stage of the investigation, making it extremely difficult for him to obtain bail. Other provisions relating to the admission of evidence and electronic media have also been provided for. In such a situation, it has to be ensured whether the investigation from its very inception has been conducted strictly in accordance with the provisions of this 2015 Act. It is a sound rule of construction that the substantive law should be construed strictly so as to give effect and protection to the substantive rights unless the statute otherwise intends. Strict construction is one which limits the application of the statute by the words used. Stop.